Welcome to Talk Trial.
But good to be back in the deep end.
Today, we are opening the file on a case that is, well, in many ways, it's the white whale of the American justice system.
Oh, absolutely.
It's a trial that is famous precisely because it never technically happened. We were talking about the United States of America versus Theodore John Kaczynski.
Better known to the world, of course, and to history as the Unabomber.
But if you think you know this story because you remember that, that famous police sketch, the guy in the hoodie and the aviator sunglasses, you probably only know half of it.
Just the tip of the iceberg.
Because the manhunt, that was really just the prologue, the real drama, the part that, it keeps legal scholars up at night, that all happened after the handcuffs went on.
That's so true. This case is often called the trial that wasn't, but that's a bit of a misnomer, really.
Yeah.
It's a war. A war. It just wasn't a war about guilt or innocence. It was a battle over the very definition of sanity, the rights of the accused, and, this really fundamental question, who owns a defense strategy? Does the brilliant lawyer, the one trying to save a client's life, get to control the narrative? Or does the client, the accused, get to control the narrative to save his life's work?
It's the ultimate showdown. You have the longest manhunt in FBI history, a defendant who is a certified genius mathematician turned hermit.
And a courtroom meltdown that almost turned a federal trial into a suicide mission.
That is a legal labyrinth.
It really is. So let's walk into that courtroom.
Let's start with the defendant, because to even begin to understand this trial, you have to understand the mind of Theodore Kaczynski. And this isn't your typical criminal profile of a drifter who just snapped one day.
Oh, far from it. This is a man who, on paper, should have been one of the leading academics of the 20th century. Born in 1942, Kaczynski was a prodigy in the truest sense of the word.
He skipped grades, right?
2 grades. He entered Harvard at 16 years old.
16? Just think about that. At 16, I was trying to figure out how to parallel park. He was at Harvard.
And not just surviving there, he was thriving. He went on to the University of Michigan for his PhD in mathematics. His dissertation was on a field called boundary functions.
Which sounds incredibly complicated.
It was so complex, so dense, that one of his professors famously said there were maybe like 10 or 12 people in the entire country who could actually understand what he had written.
Wow. So he gets his PhD and then lands a job at UC Berkeley.
Right. Becomes the youngest assistant professor they had ever hired. He's on the fast track to tenure, academic fame, the whole 9 yards.
And then...
he just unplugs. In 1969, he resigns.
Just like that.
Just like that.
Yeah.
No real explanation, no backup plan. He just walks away from it all. He moves to Lincoln, Montana, and builds this tiny 10 by 12 cabin with his own hands.
The famous cabin.
The famous cabin. No electricity, no running water. He effectively secedes from society.
And that's where the narrative takes a very dark turn. It shifts from eccentric genius to domestic terrorist because he didn't just want to be left alone.
No, he wanted to strike back. He wanted to wage a war.
So from 1978 to 1995, that's when the bombing campaign starts.
And it is terrifying in its longevity. You're talking about 16 bombs over 17 years. It's just sustained.
And the human cost was immense.
Immense. 3 people killed: Hugh Scruton, Thomas Moster, and Gilbert Murray. And 23 others injured, many of them just horribly maimed for life.
The FBI, they called the case Unabomber.
Yeah, that was their internal code name. It stood for University and Airline Bomber, because those were his first targets.
But his targets evolved, didn't they?
Oh, definitely. As his ideology, his philosophy really hardened, his target list expanded. He went after computer store owners, forestry lobbyists, geneticists, basically anyone he felt was a key cog in what he called the industrial technological system.
We really need to talk about the bombs themselves, because in the world of forensics, these devices were, they were something else. They weren't just pipe bombs you could buy parts for at a hardware store.
No, not at all. They were engineered works of art in a really macabre sense. They were the physical embodiment of his anti-technology philosophy.
How so?
Well, he handcrafted everything. He would take batteries, for example, and meticulously peel off the commercial casings so they couldn't be traced back through lot numbers.
And the materials he used were unusual.
Very. He used wood extensively.
Yeah.
Sometimes the bomb body itself was carved out of wood. He fashioned the triggers, these very unique flip switch mechanisms, out of hickory wood.
So he was using nature to build machines designed to destroy technology?
Precisely. The symbolism was incredibly important to him. He was making a statement with every single component.
And he signed his work, didn't he? There was a signature of sorts.
He did. He stamped the initials FC onto the metal components of the bombs.
FC.
It stood for Freedom Club. He wanted the world to think there was this larger revolutionary group. But of course, the Freedom Club was just him, alone in his cabin. He made sure to stamp it deep enough that even if the bomb detonated, a fragment with that stamp might survive. He wanted credit.
So you have this ghost. For 17 years, the FBI is just completely in the dark, chasing a phantom. Millions and millions of dollars, thousands of man-hours, and they have basically nothing.
Nothing. A dead end at every turn. And then Kaczynski's ego gets in the way.
The manifesto.
The manifesto. Industrial society and its future.
In September 1995, he sends out this ultimatum. He says, publish my 35,000-word essay in the Washington Post and the New York Times, or the bombing will continue and it will get worse.
And this sparked a massive, massive ethical debate inside the Department of Justice, with the FBI, and in the media. I mean, do you negotiate with a terrorist?
Right. If you print this, are you just encouraging every other person with a grievance and a typewriter to do the same thing?
It's a huge risk. But the FBI task force, particularly the agent in charge, Terry Turchi, they push hard for publication.
Why? What was their thinking there?
They were banking on a miracle, a long shot. They hoped that somewhere in those 35,000 words, someone, somewhere, would recognize the voice. Not the handwriting, it was typed, but the intellectual voice, the specific phrasing, the rhythm, the pet theories.
And that gamble paid off in a way that feels like it's straight out of a movie script.
It really did. Across the country, David Kaczynski, Ted's younger brother, is urged by his wife to read the manifesto.
And he recognizes it.
He does, but it's a process. He wrestles with it. The philosophy itself, the anti-tech stuff, that sounded familiar, but that could be a lot of people. But then he found the linguistic fingerprint.
The cake phrase.
The cake phrase. It's a common idiom, to say you can't have your cake and eat it too. But the manifesto reverses it. It says you can't eat your cake and have it too.
Which, if you really stop and think about it, is actually the more logically correct way to say it.
Exactly. You can possess a cake without eating it. But once you eat it, you no longer possess it. It's a logician's correction of a messy, common idiom.
And that was the key.
That was the key. It was a phrase their mother used constantly. That specific, odd linguistic quirk was the thing that convinced David. And that realization led him to the absolutely agonizing decision to contact the FBI about his own brother.
So let's fast forward to April 3, 1996. The FBI descends on that tiny cabin in Lincoln, Montana. And I want to pause on the search itself, because this wasn't just a quick toss the room and grab some evidence.
No, this was more like an archaeological excavation. The execution of the search warrant lasted 9 days. You have to imagine this tiny 10 by 12 foot box, just packed floor to ceiling with books, tools, papers.
And they found more than they ever could have bargained for.
Oh, they hit the jackpot. They expected to find maybe some bomb-making manuals or some suspicious chemicals. What they found was a fully operational bomb factory.
And a live bomb, ready to go.
Sis, under the bed. A fully functional device, already wrapped up in a package, ready to be mailed. I mean, if the agents had kicked the door in the wrong way, or if there had been some kind of booby trap, we would be telling a very, very different story.
But beyond the actual explosives, they found the mind of the man laid bare.
They found his journals. 40,000 pages of handwritten journals.
40,000.
40,000 pages, detailing everything. They found 240 binders filled with what he called his experiments. He treated his crimes like a science project.
What do you mean by that?
He would describe a detonation that, say, blew a man's hand off, and in his journal he'd write, results adequate or satisfactory detonation. It was so chillingly detached and clinical.
And they found the holy grail of evidence.
The typewriter.
Oh.
An old L.C. Smith Corona. The FBI's forensic team matched the imperfections in the typeface perfectly to the manifesto and to all the letters he'd sent to his victims over the years. It was an absolute slam dunk, there was no doubt.
So he's caught, he's indicted. The Department of Justice makes the decision to try him in Sacramento. Why Sacramento specifically?
It was a strategic choice. 4 of the 5 crimes that were still within the statute of limitations, and more importantly, the ones that carried the death penalty, had what's called a venue nexus to the Eastern District of California.
Meaning they were either mailed from there or they detonated there.
Exactly. So that's how the trial was going to be held. And the stakes could not have been higher. Janet Reno, who was the Attorney General at the time, she authorized the U.S. Attorney to seek the death penalty.
Which must have been just devastating for David Kaczynski.
It was a profound tragedy for him. He had turned his brother in with the hope and, perhaps a naive understanding that he could save Ted from execution. He wanted him to get psychiatric treatment, not to be killed. But the government looked at the carnage, the years of terror, and they said, no, we are going for the needle.
This brings us to the legal arena, and this is really where the story shifts from a police procedural into a psychological thriller. Let's look at the teams who are gearing up for this fight.
Okay, so on the prosecution side, you have Robert Cleary, Stephen Frashero, Stephen Lapham. Their job was, on the facts, pretty straightforward.
Easy, you could say.
I mean, relatively speaking, yes. They have the bomb, they have the journals with the confessions, they have the typewriter. Their strategy was simple. Prove he was cold, calculated, remorseless, and that he deserved to be executed for his crimes.
And on the defense side?
The defense was a dream team of capital defense attorneys. Quinn Denver, the federal defender for the district, and Judy Clark.
Now, if you follow criminal law at all, the name Judy Clark means something very specific.
It does. She is the lawyer you call when there is absolutely no doubt your client did it, but you want to save their life. She defended Susan Smith, who drowned her kids. Later on, she'd defend the Boston Marathon bomber Dzhokhar Tsarnaev and the Tucson shooter Jared Loughner. Her specialty is humanizing people the world sees as monsters.
But she and Denver had a huge problem from the get-go. The evidence was just irrefutable. You can't stand up in court and argue it wasn't him.
Right. Factual guilt was completely off the table. So the only battleground was the penalty phase. The entire defense strategy was built around one single goal: convince a jury that executing this man would be a moral wrong.
And how on earth do you do that for the Unabomber?
You argue that he isn't fully responsible for his actions. You argue mental defect. The defense's plan was to portray Kaczynski as suffering from a severe case of paranoid schizophrenia.
So they would use his life as evidence of the illness.
Exactly. They wanted to drag his primitive lifestyle, his poor hygiene, his complete estrangement from his family into the light and say to the jury, look at this man. These aren't the choices of a political revolutionary. These are the symptoms of a profoundly sick man.
But here's the massive, massive friction point in this entire case. Kaczynski didn't see himself as a sick man.
Not at all. He saw himself as a soldier, a visionary. To Kaczynski, the mental illness defense was a fate worse than death. He truly believed his war against technology was a rational political act. He believed the manifesto was a work of genius.
So if his own lawyer stood up in court and called him crazy,
it would discredit everything he had ever done. It would completely undermine his entire life's work. It would turn his political statement into the ravings of a lunatic.
So you have this incredible, almost impossible conflict. The lawyers believe the only way to save their client's life is to essentially destroy his reputation and his ideology.
And the client believes the only way to save his reputation and ideology is to risk his life. It's a collision course.
And that tension finally exploded with the filing of something called the 12.2b notice.
Yes, that was a point of no return.
Walk us through that. What is a 12.2b notice? It sounds like dry legal procedure, but here it was everything.
It's a rule of federal criminal procedure. And basically it says that if a defense team intends to introduce expert testimony about the defendant's mental health at trial, they have to give the government advance notice. It's like opening a door. Once you file that piece of paper, you're officially telling the court mental health is now in play.
And Kaczynski's reaction to his lawyers doing this?
Betrayal. Absolute profound betrayal. There's a moment in one of the pretrial hearings where he realizes in real time that his lawyers are sharing psychiatric reports with the prosecution reports that call him delusional, paranoid, schizophrenic.
What happened?
He was sitting at the defense table and he just slammed his pen down.
Yeah.
Just whack. It skittered across the table. And for a guy who was usually so stoic and stone-faced, that was a scream of pure rage.
So we move into late 1997. Jury selection, what lawyers call voir dire, is starting. And Kaczynski is watching all this happen in slow motion.
He's watching his own lawyers pick the jurors who will decide his fate. And he's brilliant. He's a logician. He can see the pattern. They're asking potential jurors questions like, how would you feel about a defendant with a severe mental defect? Or, do you believe mental illness can reduce a person's moral culpability?
They were stacking the jury.
They were stacking the jury with people who would be sympathetic to an insanity or mental defect narrative. He realizes they're building a cage for him, but it's a narrative cage.
A padded cell, metaphorically speaking.
Exactly. And he tries to stop it. He tells Judge Garland Burl Jr. that he wants to fire his lawyers, dismiss his counsel.
And the judge.
Judge Burl denies the request. He says, essentially, we are on the eve of trial. You have world-class lawyers representing you for free. We are not stopping this train now.
So Kaczynski is trapped. He can't fire his lawyers. He can't stop their strateger. So on the night of January 7th, 1998, the night before opening statements were supposed to begin, he takes the most drastic action he can think of.
He attempts suicide. He tried to hang himself in his jail cell using his own underwear.
Now, we need to stop there for a second, because the interpretation of this single act is really the crux of the entire case, isn't it? Was this an act of madness?
That's the million-dollar question. The defense would certainly say, see, he's unstable. He's so sick, he tried to kill himself. But if you look at it from Kaczynski's internal cold logic, it was a brutally rational act.
How so?
He calculated that death was a better outcome than being publicly and permanently labeled as insane. He wanted to short-circuit the trial. If he's dead, his lawyers can't stand up and give their opening statement. The mental defect narrative never gets entered into the permanent record of the court.
He survives the attempts, though. The marshals intervene and save him. And the next morning, January 8th, the courtroom is packed. Everyone is expecting to hear the opening statements, but instead, Judy Clark stands up and drops a legal bomb of her own.
She announces that her client, Theodore Kaczynski, wants to represent himself. He wants to go pro se. And this triggers a massive legal argument. There's a famous Supreme Court case that governs this, right? Ferretta
v. California. It's a landmark case. And it basically says that a defendant has a constitutional right to represent themselves. It doesn't matter if they don't know the law. It doesn't matter if they're going to do a terrible job.
It doesn't even matter if their strategy is essentially legal suicide. Correct. As long as they are deemed competent to stand trial and the request is timely, the Constitution says you have the right to be the captain of your own ship, even if you are planning to sail it straight into an iceberg.
And Kaczynski made it clear he was ready to go. He told the judge, "I'm ready to proceed immediately." He didn't want to delay. He just wanted to stop his lawyers from speaking for him.
He wanted a political trial. He wanted to stand up and tell the jury, yes, I did it. It was necessary. And here's why technology is evil. He wanted to use the courtroom as a platform for his ideas.
But Judge Burrell says no. Why? What was his reasoning?
This is where it gets incredibly controversial among legal scholars. Judge Burrell denied the request on two grounds. First, he said it was untimely because the jury was already impaneled and sworn in. And second, he called it a tactic to delay the trial.
Even though Kaczynski explicitly said, "I don't need a delay, I'm ready now."
Correct. The record shows Kaczynski was willing to proceed immediately. The delay argument was, frankly, very weak. Many scholars think Burrell got this ruling wrong.
So what was really going on?
You have to look at the context. This was happening in the shadow of the O.J. Simpson trial. The court system was terrified of another circus. Judge Burrell did not want a man he believed to be mentally ill cross-examining bombing victims on live television while ranting about technology. He viewed the request to self-represent as a tool of disruption, not as a genuine assertion of a constitutional right.
So to settle this standoff, because the defense is saying he's crazy and Kaczynski is saying I'm perfectly sane, the court orders a competency evaluation.
Right. They need an expert to break the tie. And they bring in a heavy hitter, Dr. Sally Johnson. She's a top forensic psychiatrist for the Bureau of Prisons, the same one who'd evaluated John Hinckley Jr., the man who shot Ronald Reagan.
And she spends a lot of time with him.
A lot. Over 22 hours of interviews with Kaczynski in his cell.
And her final diagnosis is, it's very nuanced, isn't it?
It is. She diagnoses him with schizophrenia, paranoid type. But she lists that diagnosis as provisional. That's a bit of a hedge. She also gives him a firm diagnosis of paranoid personality disorder with antisocial features. She confirms that he has a rigid delusional belief system, especially regarding technology and his perceived victimhood at the hands of his parents.
But, and this is the big but, the crucial finding.
She finds him competent to stand trial.
Okay, you have to explain that to us. How can you be schizophrenic and delusional, but also legally competent?
Because competency in the eyes of the law is a very, very low bar.
Right.
It does not mean mentally healthy. It just asks two basic questions. One, do you understand the charges against you and the roles of the players in the courtroom? Do you know what a judge does, what a prosecutor does?
And Kaczynski, being a genius, obviously did.
Better than some of the junior lawyers, probably. And the second question is, can you assist your counsel in your own defense if you choose to? And again, the answer was yes. Dr. Johnson noted that he didn't have any bizarre delusions. He wasn't hearing voices from Mars or seeing invisible people. His delusions were his tightly wound, internally consistent ideology. So, under the legal standard, he was competent.
So Kaczynski must be thinking, great, I'm competent. Dr. Johnson, the expert, said so. Now, Judge, let me fire my lawyers and represent myself.
And Judge Burrell still says no. He receives Dr. Johnson's report, and he rules that even though Kaczynski is competent, the request to represent himself is still a manipulation. And then he makes the ruling that finally broke Kaczynski.
Which was?
He rules that the defense lawyers can present a mental illness defense over Kaczynski's explicit objection.
That feels incredibly paternalistic. The court is basically saying, we know what's best for you, even if you hate it and it violates your autonomy.
It is. It's the system protecting the system from itself. The court was simply not going to allow a man to, in their view, talk himself onto death row while ranting about the evils of industrial society. It was too messy, too unpredictable.
So Kaczynski is completely cornered. He's in a box with no way out. If he goes to trial, his own lawyers, his own team, will stand up and call witnesses to testify that he is a lunatic.
And that was the one thing he could not bear. So with no other options, the government and the defense cut a deal.
The plea agreement, January 22nd, 1998.
It was the only card he had left to play. Kaczynski agreed to plead guilty to all federal charges against him. In exchange, the government took the death penalty off the table.
He accepted life in prison without the possibility of parole.
Right, and he waived his right to appeal on almost all grounds. He did preserve the right to appeal the self-representation ruling, but for all intents and purposes, the case was over.
The allocution, that moment in court where the judge goes through the charges and asks, did you do this? It must have been surreal.
It was chillingly mechanical. The prosecutor would stand up and read these horrific details. On this date, you placed a device in a parking lot that blew apart Hugh Scruton. And Judge Burrell would turn to Kaczynski and ask how he pled. And Kaczynski would just stand there ramrod straight and say, yes, Your Honor. No emotion, no hesitation.
He was admitting to mass murder like he was confirming a dinner reservation.
Because to him, the yes, Your Honor was the victory. It was better than the alternative. He was admitting to the crime to avoid his lawyers having to admit on his behalf to the illness.
He surrendered his freedom to save his pride.
That's a perfect way to put it.
Let's move to the sentencing hearing. This was on May 4th, 1998. This is the first time the victims and their families really get to confront the man who destroyed their lives.
And it was absolutely gut-wrenching. Susan Mosser, the widow of advertising executive Thomas Mosser, gave a statement that I think haunts everyone who was in that courtroom. She looked right at Kaczynski and said, lock him so far down that when he does die, he'll be closer to hell.
That is just raw, so powerful.
Gary Wright, a computer store owner who survived one of the bombings in Salt Lake City, he took a different tack. He spoke about the concept of forgiveness, but he also noted that Kaczynski just looked right through him, not at him. He said there was just a total and complete lack of remorse.
And Kaczynski himself, he was given a chance to speak. Did he apologize? Did he show any remorse at all?
Not a single word. He refused to address the victims. He ignored them completely, as if they weren't even in the room. Instead, he used his time to attack the government. He claimed the government's sentencing memo was clearly political and was only intended to discredit his ideas.
He was still fighting that ideological war.
To the very end. He ended his statement by saying, I only ask that people reserve their judgment about me until all the facts have been made public. He still believed that one day history would vindicate him. He wanted to be seen as a martyr for the anti-technology cause.
And the judge slammed the door shut on that for good.
4 life terms plus 30 years. And an order for $15 million in restitution to the victims. Judge Burrell made absolutely sure that Theodore Kaczynski would die in a concrete box at the Supermax prison.
Which brings us to our final segment, the 10th chair.
This is our segment where we step back from the facts of the case and offer our own assessment. And just a quick disclaimer for our listeners. This is commentary for informational and discussion purposes only. We are not giving legal advice.
So looking at the wreckage of this case, the trial that wasn't, was justice served?
That's the impossible question, isn't it? If you look at it through the eyes of the victims and their families, I think you have to say yes.
How so?
Well, they got finality. They didn't have to sit through months of a gruesome trial, reliving every horrible detail. They didn't have to worry about years and years of appeals overturning the verdict. The bad guy was caught, he admitted it, and he was permanently removed from society. For them, that's a form of justice.
And for the system itself.
The system, in a way, saved itself. It avoided the spectacle of a circus trial. It avoided the very real risk of executing a man who was clearly severely mentally ill, which would have been a moral and legal stain on the authority of the court.
But, I sense a big but coming.
The but is the process. There is a deep, unsettling constitutional question at the heart of this case. If Kaczynski was competent, and the court's own expert, Dr. Johnson, said he was, did he not have the right to make his own terrible decisions?
Under Ferretta, it certainly seems like he did.
He absolutely did. The law says you have the right to be wrong. You have the right to run a defense that guarantees your own conviction and execution. By denying him that right, Judge Burrell, with the best of intentions perhaps, essentially rigged the outcome to ensure a sane and orderly proceeding.
It feels like the system decided that Kaczynski's particular brand of sanity, his political argument, was simply too dangerous to be allowed in a federal courtroom.
Precisely. It's the ultimate catch-22, isn't it? Kaczynski had to plead guilty to save his mind from being labeled insane. His lawyers, meanwhile, tried to plead him crazy to save his life. The plea deal was the only escape hatch that allowed him to silence the mental health narrative he despised, even though the cost was spending the rest of his life in prison.
And the irony of it all is just overwhelming when you think about it.
It really is. I mean, think about this. His lawyers used his own writings, the manifesto that was meant to be his magnum opus, the thing meant to spark a worldwide revolution, as the primary evidence of his insanity. The very thing he created to prove his brilliance became, in the eyes of the court, the ultimate proof of his sickness.
It's just a tragedy of ego, of law, and of violence all rolled into one.
And it forces us to ask a really hard question. Who is a criminal defense really for? Is the lawyer's highest duty to save the client's body, even if it means destroying what the client sees as their soul?
That is a question that does not have an easy answer. And that is a wrap for this deep dive into United States v. Kaczynski.
Thanks for listening to Talk Trials.
We'll see you in court, or at least on the next episode.